Like a...
Yeah.
Good evening. My name is Jehan El-Jourbagy, and I serve as an associate professor of business law and ethics here at Georgia College and State University. It's my privilege to welcome you to this year's Supreme Court Review. This event will begin with an overview of the court and the most recent term. So those of you who have an assignment that says OT 23, that refers to October term 2023. And then we're going to have three guests who are going to discuss three cases, and then time after each presentation for questions. So I'd like to encourage you to think about a question that you might have, and then we'll have about 5 minutes after each speaker goes to ask those questions, and we'll bring a mic out to the audience to hear your questions. This event is also being recorded. This event will be shared on YouTube and shared elsewhere, so I just want to let everyone know of that. So we aim to conclude by 7:15 p.m., at which time there will be a reception in the atrium just outside where there will be Chick-fil-A, but you have to stay in order to enjoy that part of the evening. So we're going to go ahead and get into the Supreme Court for this year. These are our justices in the front row center. That's our Chief Justice John Roberts. To his right, or your left, that is Justice Clarence Thomas. He is from the Pinpoint community of Georgia. He's the longest serving justice on our Supreme Court at this time, and he was nominated by George H.W. Bush. Now to the right of our Chief Justice is Justice Alito. Both he and our Chief Justice were nominated by George W. Bush. On the far left, that's Sonia Sotomayor. She was nominated to the court by Obama, as well as the far right justice, that is Elena Kagan. And in the back row, on the left side, those three justices were the Trump nominees. The tallest gentleman, that's Judge Neil Gorsuch. And then to his right is Brett Kavanaugh, and to the far left is Amy Coney Barrett. And the newest justice nominated by President Biden is Ketanji Brown Jackson. So some notable facts from this last term is that there were 102 litigants that argued before the Supreme Court. Of the people who, these are attorneys, right, that went in front of the Supreme Court. Of those 102 lawyers, 71% were male. There were 48% of those attorneys who clerked for a Supreme Court judge in the past. And you might guess that the law schools that they came from were Harvard, Yale, and then the third one was Chicago. Now, they represented lots more law schools, but those were the highest ones represented. This term was notable. So a term starts in October, and this year it ended in July, which was unusually early. It's the earliest since 1995, other than the COVID terms in 19 and 20. Another notable part of this term was that there was a case that was overturned. That particular case that was overturned is called Chevron versus Natural Resources Defense Council. That was a case that was decided in 1984, and basically it held that courts would give deference to agencies, like administrative agencies, in the event that a law is ambiguous in some way. And so those two cases that you see, Loper Bright and Relentless cases, overturned that long-standing precedent. This chart right here has got a lot of information on it, but it shows you all the majority opinions in the last 20 years. So in blue at the bottom are the number of majority opinions that have been issued by the courts. And for a long time, they averaged around 80. But in the last several years, you can see this is the COVID year, there were only 53 cases. And then it only ticked up by one. In 20, it jumped up a bit to 57. And then in 22, it was 58 cases. And just last year, it was 59. I think that might be of interest to our Court of Appeals judge because he alone probably has like 30 that you have to, in terms of cases that you, each term, you deal with 30 alone. Okay, and so these 9 justices split among them 57 cases. And so here's one individual at our Georgia Court of Appeals level that's having to handle alone about 30 cases. So it just shows you how few cases actually make it to the Supreme Court. Now, there are a lot more cases that people try to get there. About 4,000 to 7,000 cases try to get to the Supreme Court, but only 57 came out. In this last year, 59. Of those decisions, about 46% were unanimous. So looking at this bottom one, this is from our most recent term, we've got 46% where you've got 9-0, like 9 agreeing with each other. In this time period, we were looking at 6 years, for 4 of them, it was really low. We had very few unanimous cases, and so there's been more lately in the last 2 years. So some other statistics from this most recent term is that 46 cases were unanimous, 8% were 8-1 or 7-2, 9% were 5-4, and we had 37% were 6-3. Now, since the creation of the court's conservative supermajority in 2020, the term saw the most ideological splits of any term aside from 2021. So I'm going to show you cases that split 6-3 or 5-4. All right, so back here in 2020 and 21, you see a lot of cases that were split ideologically. And some of you are like, what do you mean by ideologically? What I mean by that is that the ones that were nominated by Republican justices, who are sometimes called conservative justices, and the ones are circled in red, the ones that were nominated by Democratic presidents, sometimes called liberal justices, who were circled in blue, those 6-3 split was exactly down those lines over here. So that's what we're looking at, those 14 cases in 2021, that was down those lines. So in this year, you had more cases than the year before, but there's actually more, there were 11 cases that didn't split quite that way. You had 6-3 splits that weren't down those traditional lines. Now, some of you who read charts pretty well, this is the percentage where judges are in agreement. So the high number is going to be most agreement, low numbers are the least, where you have the least agreement. So can you find the judges who had the least agreement? Shout out the number. Where do you see the least agreement? It's 50.85, right over here. And that's between Justice Thomas and Justice Sotomayor and Kagan, between Thomas and Kagan and Thomas and Sotomayor. And then on the other side, which ones are the highest? You probably see some above 90. There's a couple here. You got 96% as the highest and 94.92 is the second highest. So the highest, the most agreement between justices that are on the conservative side are between Kavanaugh and Chief Justice Roberts, and on the liberal side between Sotomayor and Kagan. There's a lot of information that I get really excited about that I know not many other people do, but I'm going to share a little bit more information before we get to the opinions or to some of the cases. So this shows how much each justice writes. Like how many opinions do they each write? So over here, the ones with the most opinions are Thomas and Jackson. And what's interesting from my perspective, and maybe not yours, is that during oral arguments, justices have an opportunity to ask questions of the litigants. And Justice Thomas almost never says anything. He almost never asks a question. But when it comes to the writing side, he authors the most opinions, and his opinions are often the longest of any of the justices, which is kind of interesting. Jackson, on the other hand, she's the newest justice. She spoke the most and asked the most questions during oral arguments, and she ties with Thomas for the most opinions written. So that's a little overview of the Supreme Court. We're going to see if you are listening. Please get out a device. We're going to do a little quiz. And there's a prize. You're like, what? This is for everyone, even the people on the stage. You are welcome to see if you can crush all the students and win the prize. All right, here's the code. So anyone who gets restricted at 25, don't worry, I've got the pro edition. We can have 200 people in this puppy. Oh, and please keep the names clean for our guests today. I shouldn't have said that. It's like an invitation to do the opposite. So while you're getting your names up there, I'll tell you what's at stake today. The winner actually gets something. You know what I can't stand, some of you guys, when you do these things in my classes? There's no prize. There should always be a prize. So here's the prize. So Aflac is not sponsoring tonight, but there's an Aflac duck. Aflac. Aflac. Okay, makes noise. It's very... I basically looked around my office. I'm like, what can I give them? Chips. We got a College of Business tumbler. Sorry, guys, all this stuff is not in your bag. Just, not. All right, we got some cookies. Is Olshik here by chance? I got a cowtail. I know you love them. Okay, all right. We got a Sharpie marker. A Georgia College magnet. Some tracks in the trail mix. I know you'd appreciate that, trail mix. Blue and green M&Ms only. A clip. And there's some other, stuff in here. All right. Wow. All right, we're going to start in about 5 seconds. Oh, 120 participants. That's pretty good. Are you ready? Question number 1 should be easy. How many justices serve on the United States Supreme Court? Please let this be 100%. Whoa, 6 of you. Those 6 are for sure not at my class. Okay. Taylor, you're in the lead? All right. Who was the most active member of court during oral arguments? Who was the most active member of court during oral arguments? Also, P.S., you have 5 seconds to answer. Okay, you gotta be fast. All right, it's Ketanji Brown Jackson. I mentioned she's the one who asked the most questions. She's the newest justice. Oh, Julia, now the lead. Is that bad? No? How many cases did the Supreme Court decide in 23? All right, it was 59. It was 59. Who's Julia? Oh, Ball, Julia Ball. What is the name of the Chief Justice? Yay, all right, John Roberts, correct. Ooh, Luca. Close. In United States versus Rahimi, the court upheld what? Upheld what? Oh, you're going to have some teaching to do today. Okay. In Trump versus United States, the court ruled a former president is entitled to what? Okay. Better on this case. Oh, who's Luke? Okay. A major case that was overruled, resulting in the elimination of administrative agency deference, is called. Oh, I think we're kind of listening. That makes me feel warm and fuzzy. All right. 2 more questions. Oh, Julia, is that Julia Ball back in the lead? She took it from you. What central concern is at the heart of legal cases related to social media and technology platforms? All right, majority of you got that right. Oh, there was an upset. Who's Taylor? Okay. Last question, you gotta be fast. How excited are you about tonight's event? Okay. All right, in third place, please stand, Jackson. All right, Jackson Rutherford. Katie? Who's Katie? I'm timekeeper. All right. And, okay. All right, and then Taylor. Taylor, where are you? Come get your event. Okay. All right. I'm going to go ahead and start introducing our first guest this evening. Switch this off. There we go. So, Judge Wade Padgett has a degree in history from the University of Georgia and a Juris Doctorate from Georgia State University. Following law school, he served as an assistant district attorney for the Augusta Judicial Circuit, where he served as a violent crimes prosecutor. He then entered private practice and eventually formed his own law firm. In 1995, Judge Padgett was appointed as an associate magistrate judge for Columbia County. He was elected chief magistrate of Columbia County in 2005. In 2009, Judge Padgett was appointed to the Superior Court bench by Governor Sonny Perdue, and on April 3rd, 2024, he was appointed by Governor Brian Kemp as the 96th judge of the Georgia Court of Appeals. Now, there aren't 96 that serve right now. There are 15 that serve, but he was the 96th that was appointed. Judge Padgett has also been passionately involved in his community, training the next generation of leaders, serving his church, and coaching youth sports. He even volunteered as a defensive line coach for Greenbrier High School for several years. Judge Padgett is going to tell us about the case United States versus Rahimi. Judge Padgett.
Okay, what if I told you that the court ruled that it is okay to take the right to have a gun away from an individual? Would that be a conservative or a liberal decision? How many think conservative? Come on, raise your hand. This is just fun. How many think liberal? Okay. What if I told you the court decided to take away the right to have a gun from a guy with a really bad record of using a gun illegally? Is that conservative or liberal? Conservative? Liberal? What you're going to see is, in the case of the U.S. versus Rahimi, there are people who are arguing both sides, that it is a conservative decision and that it was a liberal decision. I'm going to do a little shout out. There's a podcast called Advisory Opinions that I borrowed some of their analysis of this case for the purposes of my presentation. Now, let me tell you what the Second Amendment says, because there's a false pretense on what this says. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That is what the Second Amendment actually says. Now, there's another philosophy that is very informal and you won't find in any law or any constitution or any ruling that says bad guys stay in jail as a general rule. You're going to hear that this was an 8-1 decision. You talked earlier about how many were unanimous. This was 8-1. But there were 5 judges who wanted to write concurring opinions. So they agreed in the outcome, but they wanted to express a different point than what was expressed in the majority opinion, and only 1 who dissented. Now let me start by telling you the facts of Rahimi. This case came from the 5th Circuit Court of Appeals. That circuit encompasses Texas, Louisiana, and Mississippi. In case you want to know, you are in the 11th Circuit. In December of 2019, a man by the name of Zaki Rahimi had a violent altercation with his girlfriend, who is also the mother of his child. A bystander witnessed Rahimi grabbing the girlfriend, shoving her into a car, and causing her to hit her head on the roof of the car. And as the witness approached, Rahimi went and got a gun from the interior of his car. The girlfriend fled, the witness started to retreat, and Rahimi fired, unsure of who he was shooting at. I mean, nobody knows if he was trying to hit the girlfriend, trying to hit the witness, or all of the above. Then he fled. As a result of that, he was not charged with a crime. And that's going to be important before we get through this. The girlfriend went and sought a restraining order for family violence. You may have heard of these things. That is an order that says, I don't want this person to have any contact with me because they have either actually committed violence or threatened violence to me or my child. The judge found, the state court judge found that was family violence, that he was a credible threat to the physical safety of the girlfriend and the child, and so they entered the order. After that order got entered, he violated the order repeatedly, but that's not why we're here. He went to her house, contacted her by social media, things like that. But the reason that he got charged is because Mr. Rahimi was charged with aggravated assault with a handgun against a different girl while this order remained pending. So he was found to have a girl. Now, Mr. Rahimi has a bit of a record, but not a criminal record. Like when his friend's credit card got declined at a Whataburger, he pulled out his gun and shot in the air. He had shot at people at traffic things, road rage things. He had shot at people. There was a documented history of him shooting people, but he had never been charged with a crime. So he was prosecuted for violating a specific statute in the Northern District of Texas. This is called 922G. It had a little bit of familiarity. You might have heard of this. This is what Hunter Biden was charged with violating, the son of the president. 922G8 makes it illegal for a person to possess a firearm after that person has been found by a court to be a credible threat, after a restraining order has been issued. Of course, the subsequent arrest for the aggravated assault was all the proof the government really needs, so they charged him. He said, this violates my Second Amendment rights. The trial judge said, no, I don't think so, in the Northern District of Texas. He pled guilty and then filed an appeal to the Fifth Circuit. So the way it goes is that the case gets tried in the district court. If you're unhappy, you can appeal to the Circuit Court of Appeals. And then the only other option from there is the Supreme Court of the United States. So how did this case get to SCOTUS? And everybody understands SCOTUS, Supreme Court of the United States, SCOTUS. The Fifth Circuit read some recent opinions from the Supreme Court in cases such as District of Columbia versus Heller, McDonald versus Chicago, and New York versus Bruin. And I'm going to talk about that in a minute. Just understand there were some cases to say that the Second Amendment through the 14th Amendment applies to states, and that it shall not be infringed. It means what it says. Therefore, despite any alleged activities or illegal acts, not crimes, illegal acts that Rahimi was alleged to have committed, the Fifth Circuit said, well, we have this right shall not be infringed, and so he gets to have a gun. He shouldn't have been charged. The government said, oh, hold up now. And so they appealed to the Supreme Court, and the Supreme Court took the case. Now, when I learned constitutional law when I was in law school, we were told that the constitutional rights that you have through all the different amendments, that they're really important, and that the government can only take those rights away from you if they have a very specific need. It's an important government interest, and they have to write the law as narrowly as possible to accomplish that goal. We called that tiers of scrutiny. In Rahimi, and a case before it called Bruin we're going to talk about, they said, no, you don't need to figure out whether or not it's an important right or only if it's crucial or important or really important. You don't need to worry about that. All you need to do is go back to the history of the United States. Easy, right? Go back to the history of the United States and see at the time they passed the Constitution were there some similar restrictions in place. Now, for those of you who might be interested in this, there weren't any AR-15s or AK-47s when they had muskets and whatnot and people in red coats and blue coats. So how would the Second Amendment apply to high-capacity magazines and guns or rifles or even semi-automatic handguns? Those things didn't exist. What the Supreme Court says is that you have to look at the history of our country, the text, and any precedent that they have decided before, and see if there is a historical reference for this kind of restriction. If there is, it's okay. If there's no historical reference for it, it's not. Now, I just pointed out that there weren't AKs and ARs and high-capacity magazines and all that way back then. So clearly nobody was talking about that at the legislature or with Congress or at the time of the Declaration of Independence and or Constitution. There wasn't anybody talking about that because it wasn't a thing. Of course, there also wasn't electricity. So you've got to keep in mind that if this Constitution thing that we created is going to have any viability going forward, it has to be adaptable to things that didn't exist back then. Otherwise, it's useless. It's frozen in time. So basically, the court said, you know what? Let me tell you about these three cases. Heller. In Heller, the District of Columbia said that they banned possession of a handgun, made it a crime to carry an unregistered firearm, but then just to kick it, they said you can't register a firearm. So in other words, they made it a crime for you to have a handgun. It did allow the police chief to issue a 1-year license, but it required all firearms that issued under that license had to be unloaded and either disassembled or bound by a trigger lock. When that case went to the Supreme Court back in 2008, the Supreme Court said, no, that violates the Second Amendment. Because the Second Amendment was meant for you to have firearms for self-defense, and that defeats the entire process. So that was Heller. In McDonald, the city of Chicago and the city of Oak Park, which was right there together, they had laws effectively banning possession of firearms. They said, but you know what? The Second Amendment only applies to the federal government. We're local government. We're state. So that doesn't apply to us. They said, nope. Through the 14th Amendment to the United States Constitution, all of that in the Second Amendment also applies to states, so you can't do that. Finally came Bruin, and this is New York versus Bruin. This was a 2022 case. In New York at that time, it was a crime to possess a firearm without a license, either inside or outside of your home. Their laws allowed for a person to apply for a license to carry a firearm outside the home only if he could prove, and I'm going to use air quotes, proper cause to prove that he was in a unique situation to need a firearm. As an aside, that included police officers who were off duty. They could not carry a firearm unless they had a license. This proper cause requirement was only met if the applicant could, quote, demonstrate a special need for self-protection distinguishable that from the general community, end quote. The Supreme Court took Bruin and they said that is a violation of the Second Amendment. You can't do that. You can't prevent law-abiding citizens from having to prove that they need something for self-defense because that defeats the Second Amendment. So when the Fifth Circuit got Rahimi, and I'm going to tell you an aside that most people don't talk about, when they first decided Rahimi, they ruled against Rahimi. Then Bruin came out and they reconsidered it and flipped it and ruled in Rahimi's favor. Because they said, looking at Bruin, You can't take away somebody's right to possess a gun under the Second Amendment. You just can't. So then the Supreme Court takes it. So they said 922G, the Fifth Circuit said 922G was unconstitutional. Here it comes to the Supreme Court. And to be honest with you, it's not hard to see how the Fifth Circuit got there. Based upon those rulings, it was sounding a whole lot like you could never take a gun away, you can never take a gun away, you can never take a gun away. In Rahimi, Chief Justice Roberts, who y'all met a few minutes ago, he wrote the majority opinion. He said, hey, courts, y'all are misinterpreting our cases. He said, for a firearm challenge to survive under the Second Amendment, for a regulation to survive under the Second Amendment, the government must show that the regulation is, quote, consistent with our nation's historical tradition of firearm regulation, end quote. Now, we've just established that we didn't have these kind of guns back in the beginning, so they said, you know what, you don't have to have something that is identical. You don't have to have an old law that was identical to this law. You have to have something that was close. There was an old law back in the day called going armed. It prevented somebody with a documented history of using weapons to threaten or menace other people. There was also surety laws that if you were kind of showing out in town, you could be required to post a bond or money in order to have a weapon. And the Supreme Court said those laws are similar enough to this law to be legitimate. I'm going to tell you that there were 5 concurring opinions. They all made different points, but one of them specifically I would suggest to you is important. They said, you know, doing this historical analysis is hard, but that keeps the judge in his lane. Because judges aren't supposed to make law, they're supposed to interpret law. And if you do that hard analysis, that keeps you from putting your viewpoint on what the law should be or shouldn't be, and instead have to point to proof that supports your opinion. Justice Thomas wrote the dissent, and he said, nope, everybody should be able to have a gun pretty much all the time. That's an oversimplification of what he said. Now, I said real quickly the bad guy stays in jail comment. The Supreme Court gets to pick their cases. You saw that in the stats. They pick the cases that help them get to where they want to go sometimes. They would never tell you that. They would never say that, but it's painfully obvious to those of us who read these cases. So while not any sort of real criteria, I'll tell you that when you have something as egregious as Rahimi, it makes it much easier to support a Second Amendment restriction than when he doesn't. So I think that's all the time that I have.
We have 5 minutes for questions.
Ask me questions, please. Yes?
What's your opinion on that?
What's my opinion on Rahimi? Well, we're being filmed. So at the Court of Appeals, we don't generally come to constitutional issues that often, but if I ever went to the Supreme Court, I would tell you this. My impression of this case is that there has to be the ability to restrict gun rights and gun usage in some level. I am a gun owner. I have a bunch of them. But I also understand that when your conduct causes us as a society to be concerned, like recently in Winder, we have to have a way to take some level of firearm away from somebody when they give you enough red flags to suggest that they have lost that right. Their conduct, their mental health, their drug abuse, their whatever. I think this decision makes a lot of sense. You can debate however you want to how they got there, but I think it makes a lot of sense. Yes? Isn't there a law against killing other human beings anyway? Yes, we call that some form of homicide, either murder, manslaughter, whatever. And that's one of the points that people made about Rahimi is that, look, we have laws that say if you're a convicted felon, you can't have a gun. But nobody ever prosecuted the guy. He was apparently just a menace. running around shooting at all kind of people, even at Whataburgers, and nobody had ever convicted him. And so one of the real problems with this case is it was based on a family violence protective order, not on a prior conviction. If he had been convicted, I don't even know that the Supreme Court takes this case. But because it was based upon a family violence protective order, not a conviction, it was a much closer call. Yes?
In Georgia, I know before 2008, when I was about to look at protective orders, that was part of the order that the gun would be removed from the home. Has that changed since?
So the question was, she has some history with helping people get in protective orders. I will tell you that we have some appellate law that says that's illegal. We can't take your gun. It's just this is a practical issue. Where are we going to put it? Do we put it in evidence? What if you have 48 guns? Now the sheriff has to be responsible for keeping up with the guns. We take away your right to possess them. When I was a Superior Court judge, more often than not, when I would issue these orders, I would order you to divest yourself of them, and you identify to me who you're going to give them to. Your grandpa, your best friend, whatever. I think there's a mistaken impression that if we tell you you can't have a gun, that means you can't go get a gun. I mean, let's be realistic. If somebody is a bad enough actor, they can find a gun. If you want cocaine, you can go find it, right? So the fact that we make it illegal doesn't make it impossible to get. It may make it harder, but it doesn't make it impossible. So the case law basically said you can't preliminarily take them away from that person. And we could have hours of conversation about temporary protective orders and family violence and how hard it is to legislate people to do the right thing, because sometimes we can't. All right, I think that's my time. Thank you very much.
So he mentioned there's a majority opinion in that case, 5 concurrences and 1 dissent. So 7 separate opinions in one case, which is kind of unusual. And our next speaker today is someone that I've gotten to know through a professional organization that I'm a part of. She is, Ivy White is an Atlanta native, but she went to high school in South Florida. She earned her associate degree in accounting from Florida Atlantic University. She's a 3-time Georgia State University alum, having earned her bachelor's degree in Spanish. I learned all kinds of new things by reading her bio today. And her JD and MBA from GSU as well. And at the same time? Wow, okay. In 2016, she was selected to deliver the student address at Georgia State's Law's commencement ceremonies, where she received a standing ovation, so no pressure today. Okay. While in law school, White was a student attorney on the school's mock trial team, and by her 3rd year of law school, she was already representing domestic violence victims in Cobb County. She clerked for the Honorable John Goger and the Honorable Alfred Dempsey in Fulton County Superior Court. Throughout her career, White has practiced in the areas of family law, personal injury law, workers' compensation, insurance defense, and business law. She serves as a clinical assistant professor of legal studies at Georgia State University and is a certified mediator. And she's going to share information about the case Trump versus the United States.
I hope I make my case as exciting as you did. I don't know. All right, let me open up my notes here. All right, so how many of you all are familiar with Trump versus United States? If you're on social media, I know for sure that you've heard of Trump versus United States. All right, so what I'm gonna do is I'm gonna start with the facts on this case, and I'm gonna give them to you in a particular way, because somebody told me a long time ago, you can either tell me the story of the young lady who was a truant and broke into people's houses and broke all of their stuff and ate their food, or you could tell me the story of Goldilocks and the 3 bears, right? So it's really all about the way that you frame the facts. And in this case, the way that facts are framed is really important because it determines the character of how we treat the president's behavior, right? Or conduct, I should say, okay. All right, so let me start with telling you a little bit of background. So back in, after the November 2020 election, President Trump at that time challenged the validity of the election results. Based on different statements that were made, there were allegations that were brought that he made statements that incited the riot in DC, right, at the Capitol. I am going to give you the facts as they are in the indictment that was brought against him for some of the actions that he took. And the reason that I say it that way is because his counsel described his actions differently, okay? All right, so according to the indictment, President Trump and his co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to change electoral votes from Joe Biden, Trump's opponent, to Trump. Okay. The second allegation was that Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states and caused those fraudulent electors to transmit false certificates to the vice president and other government officials to be counted at the certification proceeding. The third allegation was that Trump and his co-conspirators attempted to use the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed the Justice Department had identified concerns about the election outcome. All right, the fourth allegation was that Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. And following that, they repeated knowingly false claims of election fraud to gathered supporters, and that is what led to the riot at the Capitol from an angry crowd, specifically based on statements that were made by Trump, okay? Now, I want to give you the facts as framed by Trump's attorney. According to Trump and his counsel, he simply made public statements about the administration of the federal election. He's just making statements about the federal election. Number 2, that he communicated with senior Justice Department officials about investigating election fraud and about choosing the leadership of the department, okay? Number 3, he communicated with state officials about the administration of the federal election and their exercise of official duties as it pertains to that. Number 4, he communicated with the vice president and with members of Congress about the exercise of their official duties as it relates to election certifications. Number 5, he authorized and directed others to organize contingent slates of electors in furtherance of his attempts to convince the vice president to exercise his official authority in a manner advocated by him as president. Okay, so if you listen carefully, you heard that essentially I can tell you the story of the girl who broke into the house and stole people's things and broke their furniture and ate their food, or I can tell you the story of Goldilocks and the 3 bears. All right, so this is why this is important, the way that the facts are framed, is because ultimately in this case, the question was, this was an indictment. The grand jury did indict former President Trump, and former President Trump claimed that he was entitled to presidential immunity. You can't indict me for criminal charges because I am president, and so I am protected. And the reason that you can't indict me for criminal charges for my acts as president is because how can I be president if I'm worried about having to go to jail for things that I do when I'm president, right? So presidents do all kinds of things that some people might consider to be crimes. And in listening to oral arguments in this case, there were some examples, right? So let's say, for example, that a president needs to order a drone strike in another country for our national security, which is within his authority, and a US citizen just happens to be killed as part of that drone strike. Maybe they're somewhere they weren't supposed to be. Maybe we didn't know that they were there. Technically, that's murder, right? You caused the death of another person. And so, is it right? Is it fair that a president would be subject to criminal prosecution for things that they do in their capacity as president? So he said, I shouldn't have to be worried about, or a president in general, shouldn't have to be worried about the things that I did when I was president in that capacity, later on coming to haunt me, maybe because people don't like me, or maybe because people don't agree with the decisions that I made. And they pointed to an old case where it was held that a president is immune from civil liability, where they can't be sued civilly, right? We know the difference between civil law and criminal law. Civil law is a case between two individuals, two private parties, essentially. Criminal law is a case where there's some type of punishment because you violated a law, either a federal statute or a state statute, right? So ultimately, in this case, there was a lot of conversation about the balance of powers and the separation of powers in our governmental system. So we know that we have separation of powers built into our government, the way that it's created. We have different branches of government, and the reason is so that we can have a checks and balances system. And so when the United States was created from the settlers from England, the whole idea was we want to have a government that has a checks and balances system, not some monarch that gets to be above the law and tell everybody what to do, right? So on the one hand, you have the argument that in order for a president to effectively, swiftly, confidently do their job as president, which involves really important, really hard decisions, sometimes controversial decisions, they have to have the protection to know that, oh, I'm not gonna get sued for this, right? I'm not gonna have to go to jail for this, right? Because if that is the case, a president is not going to be able to act swiftly and confidently the way they need to make these important decisions. Now, on the flip side, the argument was, well, do we want a president to be able to be above the law, where they can't be punished for anything that they do? Because what if they accept a bribe? Now, are they, because they're accepting a bribe for maybe some foreign ambassador to accept a position, to get a position that perhaps they're not entitled to or qualified for? If they accept that bribe, that's a crime. Are we not gonna hold them responsible for that? What if they just go crazy, okay, and just start killing people while they're president? Are they not gonna be responsible for that? And that's an extreme example, but the reality is, and this is something that was pointed out by the Supreme Court multiple times, the reality is that once the Supreme Court is the end of the road, right? So you don't go back and reevaluate who's gonna check the Supreme Court? Nobody, right? So you don't go back and reevaluate that decision. So if you're at the end of the road and the Supreme Court says anything that a president does is protected from criminal punishment, then essentially they could do whatever they wanted. And maybe right now, today, we're not talking about an extreme example, or some people might think we are talking about an extreme example. But eventually, there may be an extreme example, and the Supreme Court has already made a decision that this president is immune from liability, from criminal liability, for anything that they did while they were president, okay? So, ultimately, the Supreme Court had a lot of conversation about these dueling interests, okay, between separation of powers, checks and balances. We don't want a president to just completely be above the law, not have to answer criminally for anything that they do, but also we want a president to be able to make the decisions that they need to make swiftly, confidently in their role as president. Okay, so ultimately, the Supreme Court broke down the acts of the president into 3 categories, right? So the first category is if the president does something that is something that they exclusively have the ability to do, the right to do, the power to do, through the Constitution. So there are certain constitutional powers that only the president has the authority to do. If it's one of those things, they have absolute immunity, okay? There's nothing, no one can check them. You cannot charge them, can't indict them, nothing, right? The Congress cannot review that act, okay, nothing. Now, the second category is if they do something that is within their authority, but not one of the exclusive powers that is reserved just for the president, then they are granted presumptive immunity. And presumptive immunity means, for the most part, you're not going to question what they did. For the most part, you're not going to question what they did. It's not really subject to review. Unless you can review that decision without causing any unnecessary burden on that position, right? So if you can review that decision and know that reviewing it does not restrict the president's authority to act, which is kind of gray, kind of warm, well, we don't know what that really means. And then, of course, the final category was unofficial acts, which means something that was done that's completely outside of his role as president, then there is no immunity for that. And so the example for that would be, like, y'all know about the President Clinton situation, the things that were going on in the Oval Office. Do you know? Do you? Okay. That's unofficial, okay? So if it's one of those kind of unofficial acts, then, right, you are subject to criminal punishment. You have to answer for those things. So ultimately, the Supreme Court said, we're not going to say that the president is completely above the law, but for the most part, we're going to restrict significantly what types of things they have to be criminal, that they have to answer for criminally. And as far as those particular things, right, so we're back to Goldilocks and the 3 bears, okay? Do you all know about the tiers of the courts and trial court and appellate court and the Supreme Court? So the Supreme Court remanded the case back down for them to take evidence about whether or not, and to make a determination about what acts were official or unofficial, what acts were within the authority but not exclusive authority where there's presumptive immunity, and which acts are acts that the president only had exclusive authority to do and cannot be questioned at all, where there is absolute immunity. So you'll just have to stay tuned to see what happens at the district court level. All right, any questions? Yes.
How does the First Amendment play into the Trump case? Like, was that ever mentioned, like freedom of speech?
No, it wasn't mentioned because it really wasn't about, the case wasn't about the content of what he said per se. It was specifically, in this case, the issue was specifically about whether or not he could be charged or indicted criminally in the first place. So they didn't get into his freedom to say certain things. It was more so, can he even be charged? Do we even have to talk? Are we even going to talk about it? Yes.
Do you know what the split was?
Yeah, so it was 7-2. So Justice Sotomayor and Justice Jackson both dissented. They felt like there was too much power left to the president, and that could be problematic. That basically, that decision gave the president, this is my favorite word, willy-nilly authority to just do whatever he wanted. And essentially, even the qualified immunity wasn't really There is no teeth to it, as we say. That really, in effect, once it plays out, there wouldn't be any authority to hold a president criminally liable for anything that he did. Now, whether or not that is true, I think we'll find out. I think this is, well, first of all, this is a really unprecedented case, right? So this is a situation that the Supreme Court is being presented with for the first time ever. So, we'll have to see how it plays out in real life, because really it comes down to how the district court views the conduct. Was it official? Was it unofficial? Was it within his exclusive authority or not? Because that's going to determine how they look at it. Yes.
So you said that the Supreme Court is generally like the end of the road. In this case, they didn't take it back. Do you think if they had come to a decision that it would have been truly long-lasting for protecting or not protecting presidents?
Well, they did come to a decision, but essentially they came to a decision that gives a framework. And that framework, it's almost like a framework that they've given for the lower courts to follow. So they did come to a decision, they just did not decide for that particular case. They didn't have the evidence because the trial court, the lowest court, is the only court that can take evidence, okay? And so they didn't have what they needed because the lower court hadn't made a determination about what acts were official and which acts were not, because they had already decided that there was no immunity at all. Yeah. Any other questions? Yes. Mm-hmm.
This decision help reinforce some of those expansions of presidential power, or is the restrictions that are put in place, does that help slow it down?
Yeah, so I think the general consensus for people who align with the dissenting justices would say that this is consistent with that trend of expanding presidential power and authority in a dangerous way. But I think if you were to ask people who align with the majority opinion, they would say, well, no, this is an expanding power for the president. This is the power that the president really should have already had, right? This is something we're just, writing it down, right? But we're not expanding the power. The president already has the power to act and needs to have this power to act, and so it's not dangerous. So I think it depends on who you ask. but it does seem like it is. It does seem like it is kind of solidifying certain powers that perhaps in the past, part of the conversation in oral arguments was, well, presidents just have always assumed that they were subject to criminal punishment for things that they did. And so now it's just kind of like putting concretely that it's very limited, right? Thank you.
Our final speaker this evening is Matt Roessing. He's a graduate of Williams College and William and Mary Law School. He began his career in Washington, D.C. in the litigation department of Arnold and Porter LLP. He represented multinational corporations in major disputes, including multi-district litigation and shareholder class actions. Roessing specialized in international trade, advising foreign companies and governments on U.S. import-export laws and representing clients before U.S. trade agencies and international arbitration tribunals. Prior to joining the Emory Law School faculty, Roessing taught business, real estate, and international trade law at business schools, first at Georgia College and State University, and then at the University of Georgia. He is a member of the International Academy of Legal Studies and Business, a founding member and inaugural chair of its Teaching and Pedagogy group, and a recipient of its Master Teacher Award. And after you see this presentation, you'll probably know why he received this teaching award. Roessing writes and speaks about legal pedagogy, business regulation, and the jurisprudence of the United States Supreme Court. He's a Supreme Court junkie, I know. He continues to represent and advise select clients in business and real estate matters. Professor Roessing is going to tell us about several cases that address social media.
Thank you very much. Excuse me one second. I've got a presentation we're going to key up. Good job, Taylor, once again. I think I got it. You just, no, you do it.
Yeah, it's kind of
All right. Well, thank you very much, Professor El-Jourbagy. I actually helped to start this Supreme Court review back around 2015 when I taught here at Georgia College. And Jehan has taken this to a whole nother level. I am always really excited and proud to come back here and see what she's done. Around that time is when I started following the U.S. Supreme Court. I found it really fascinating. At that time, and really for much of my life, although not for much of yours, the Supreme Court was on a knife edge between liberals and conservatives. We had 4 liberals, we had 4 conservatives, and then we had either Sandra Day O'Connor or later on Justice Kennedy in the middle, to the right of the middle, but occasionally joining with either side. So it made it very exciting, and a lot of these hot-button social issues, you weren't really sure where Kennedy was going to go, and it made a lot of fun to try and predict the cases. Well, that has all changed since then. Most notably, the court now has a solid conservative majority, which makes the outcomes in those close, contentious cases much more predictable. So my new interest in the court is not where are the cases going to come out, but how is the court going to address emerging technologies and new technologies? I find it fascinating to see how the court addresses these things, particularly when it comes to freedom of speech and the First Amendment. The court heard 4 social media cases this term, and the decisions were not ideological. They were not along party lines, as a lot of them are. Part of the reason for that is that they didn't really make decisions in a lot of these cases. As we're going to see, they sent a bunch of things back. Some things they decided on procedural issues, never got to the merits. But maybe one of the reasons they did that is they seem to have a very difficult time figuring out how is the Constitution supposed to apply to technologies that did not exist at the nation's founding. And here we get into this concept of originalism. The concept of originalism was really popularized by a former Supreme Court Justice, Antonin Scalia. And here's what it means in his words. What the Constitution meant when it was adopted, 1787, is what it means today, and its meaning doesn't change just because we think that meaning is no longer adequate to our times. At the time he kept saying this and writing about it, he was a bit of a lone wolf, but he brought a lot of conservatives over to his position. And Scalia is no longer on the court. He passed away a few years ago, but his legacy really continues on and has grown. Justice Barrett, Justice Thomas, and Justice Gorsuch are all proponents of this originalism theory. They've all said one way or another, we are originalists. In fact, Justice Coney Barrett was a clerk. She was a judicial clerk for Justice Scalia, and therefore follows a lot of his philosophy. So half of this current conservative majority identifies as originalists. But how do you apply an originalist perspective to a very modern issue like social media? Judge Padgett referenced this, and it's a great example. A lot of people criticize the use of the Second Amendment today by saying, hang on a second, weapons are very, very different in 2024 than they were back in 1787. The Second Amendment, when it was passed, it was designed to protect ownership of things like flintlock muskets and pistols, not AR-15s. A flintlock is a very cumbersome weapon. You've got 3 rounds you can shoot per minute with training, and you have to keep 2 of them in your pocket because you can't load them in the weapon itself. Compared to that, a modern AR-15 style weapon, it fires as fast as you can pull the trigger. The only limitation now is the human limitation of how fast you can move. A 30-round magazine is standard. With modifications, you can up that to about 100 rounds. It is light, lethal, cheap, and available at a store near you. So is the Second Amendment really intended to protect the ownership of these type of weapons? Well, if you're buying into that argument even a little bit, now consider the changes in media technology since 1787. They call it the freedom of the press because that's how media was actually developed, on a wooden printing press. You would arrange all the letters in a box, you would ink them up, and then you would physically press down on them, and that's one sheet. And if you were working, a professional printer could churn these out about 200 to 250 sheets per hour. That's not a whole lot, because remember, a paper is probably going to be multiple sheets. And then you got to get on your horse to go hand them out. Compare that with the printing press that probably every single one of you has in your pocket right now. You can reach almost 5 billion people at the speed of light. Once again, the only limiting factor is how fast you can move your fingers. In fact, you probably aren't even the limiting factor anymore. Even if your phone is in your pocket right now, it is probably, without any help from you, communicating with people all over the world. It is collecting and curating content so that it is ready for you the second you open that app. So what's Gutenberg going to say about that? What are the founding fathers going to think about this? Could they have even conceived of this technology? In fact, would the founders even recognize our modern world? I mentioned that there are about 5 billion social media users today. That is 5 times the number of people that existed in the world back in 1787. The first estimated gross domestic product for America, this was calculated in 1805, it put it at $2.5 billion. Everything in America was worth $2.5 billion back in 1805, by a reasonable estimate. $2.5 billion, today that is chump change. Take a look at the top 25 companies. Forget the wealth of nations. We now have 7 companies that are worth over $1 trillion. And also look who they are. Tech, oil, Warren Buffett. That is the power that these companies have these days, and the blue means that these are all American companies. So what's Ben Franklin going to know about this? The dude's idea of a fun Friday night was to go out and get zapped by a kite. But maybe I'm not giving enough credit. Anybody know, what did Benjamin Franklin actually do for a living? Does anybody know? This isn't rhetorical. Do you know what Benjamin Franklin's job was, his profession? How about our panelists, do you know? Well, before he was an ambassador, before he got into politics, what was his day job? What was his square job? He was a printer. He was a publisher. He was actually very good at it. He made quite a bit of money at this. In fact, not only was he a printer, he actually tried to establish an intercolonial network of printers that would all share content together. You would not be wrong to call this the first social media network. Now, it never actually got off the ground. He couldn't get other people to join him on this. But his plan was not just to share news with other newspapers and publish the same content. He actually thought this would be a way to spread moral views, to spread morality, or at least his version of morality around the country. He was also the first postmaster of the United States. Now, that may seem like a really boring job. We've got these other people becoming president, vice president, secretary of state, and he gets to be the postmaster general. But think of what that meant back in the 1800s America. His job was literally to set up some system to get messages to as many people as possible in a world where that could only happen through writing, printing, and horse travel. So quite the feat. And you can bet that if he could conceive of social media technology, he certainly would have taken advantage of it. Now, with communication comes propaganda, and Ben Franklin was a propagandist as well as a publisher. On the left here, we have a famous print by Benjamin Franklin. You've probably seen this, you probably saw it when you're coming up in school. It was urging the colonies to unite against Britain. On the right is Common Sense by Thomas Paine. This was also a very influential document in the colonies. It was printed on those wooden presses and distributed by hand or by horse. To Americans, these are some of our most treasured national documents. To the British at the time, these were terrorist recruitment pamphlets. I didn't mean for the dramatic lighting there, but I like it. However, these are clearly matters of opinion. And we can certainly see that opinions should be freely disseminated, and everybody takes them with a grain of salt. But what happens when facts are being disseminated? This is a famous quote from one of the founders of our nation. Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. Thomas Jefferson. No, I'm lying. It's not Thomas Jefferson. Who is it? Does anybody know? It's not George Washington, but you're very close. He hung out with George Washington. In fact, he's the one who recruited George Washington and nominated him to be general, and then he got a little nepotism job after that. It's John Adams, our first vice president and our second president of the United States. So John Adams was very particular about facts. As a matter of fact, one of the reasons that Adams is so well known among lawyers is not just for his role as a president and a vice president, but the fact that he defended British soldiers who were accused of committing the Boston Massacre. So this killing of a number of American citizens in Boston before the Revolutionary War by British soldiers, he came in and defended them when no one else would. And this was actually his closing statement in that case. He said, whatever you think about these folks, whatever you think about Britain, you got to focus on the facts. No fan of the British monarchy, but he put that aside to defend people who he thought needed a defense. But is he right? I just managed to convince you all he was Thomas Jefferson. And you would have left here thinking that. And can I do that? Can I just lie? Does Georgia College have a responsibility to stop me? In fact, they gave me this platform, they gave me this microphone. Are they responsible for the lies that I spread from it? When Adams was defending the British soldiers from the Boston Massacre, Paul Revere was busy politicizing this tragedy. So this is a print made by Paul Revere. Yes, that Paul Revere. He was a silversmith, he was a handyman, he did a little printing on the side. And he engraved, printed, and sold this picture. He made a little money off of it. This is his version of the Boston Massacre. You see the British soldiers lined up. You see a British commander giving an order to fire. You see them in military precision gunning down a bunch of innocent civilians, and with some of them with enjoyment in their eyes. The only problem? This was fake news. It never happened that way. Eyewitnesses at the trial of these soldiers said, no, what happened is a bunch of Americans were throwing rocks and sticks at one British soldier. He was just cowering, trying to defend himself. The other British soldiers surrounded him for protection. They all got hit with sticks and bats. And eventually, out of fear and self-defense, some of them discharged their weapons into the crowd. They were never given an order to fire. So John Adams was able to elicit that testimony, and the British soldiers, for the most part, were acquitted. However, you still remember this because you saw it in school. The American people remember this. This image stuck in their mind, even though it's not what happened. They say the pen is mightier than the sword, but one reason they say that is that the pen can summon the sword. On the left here, we have a very famous lantern. This is the Paul Revere lantern, 1 if by land, 2 if by sea. It was the symbol to the revolutionaries that the British were arriving, and there was going to be 1 lantern lit if they were arriving by land and 1 by sea. That was the fastest method of communication. He would have loved to pick up his cell phone and call people, but he couldn't, so he had to light this lantern and then get on his horse and ride all around. The British are coming. Nowadays, this is the beacon that for a short time was lit on top of X's headquarters. X is now, the new Twitter. The Ukrainian militias that were fighting against Russian invasion, they have come out very vocally to say, we use social media as part of our war effort. We are warned when the Russian troops are coming by people in villages sending us messages on Twitter, on X, and we're using social media to help bring people to our side. So whether this is a good thing or a bad thing, this ability of armies, of militias to coordinate using social media largely depends on how you feel about those men and women that have the guns. January 6th, 2021, the storming of the U.S. Capitol. It has now come out, largely in trial testimony and criminal prosecutions, that the Proud Boys and other people that led the attack on the Capitol used social media to help coordinate the attack. Live by the sword, die by the sword. They also had social media be used in their convictions. And evidence from social media was used in their criminal trials, and I presume in Trump's criminal trial as well. One of the primary purposes of government is for the protection of life, liberty, and property. But what happens when those goals conflict? What happens when they're trying to protect your property and you say, no, I don't want you to do that, you're infringing on my liberty? It's a bit ironic, given these revolutionary sentiments of just a few years before, after the 1798 Sedition Act, Paul Revere's print would almost certainly be illegal. It made printing and uttering false, scandalous, and malicious statements about government illegal. This is one of the first laws passed by our American government. Why would we do this? Because we were at war with France. And the prevailing political party thought that if the minority party was criticizing them, it would ruin the war effort, or at least that's what they said. The Federalists said, Democratic, Republican printers that are saying bad stuff about us, we're going to put you in jail because you're damaging the war effort. Even though Franklin was the first postmaster general, the Comstock Act would later make a bunch of things that he wrote be unlawful to send over the mail, because Ben Franklin wrote some pretty racy stuff. He wrote his memoirs, which he talked about his many mistresses. That was banned under the Comstock Act. He wrote a paper called Advice to a Young Man on the Choice of His Mistress. That was also banned. And a letter that he called Fart Proudly, which was a recommendation that scientists develop a pill that would make your farts smell good. Probably not what you learned in history class about Benjamin Franklin. These would not be considered obscene by modern standards, but they certainly would have been at the time. You couldn't send Benjamin Franklin's letters through the mail. And you may think this stuff's funny. Well, who cares? What about child pornography, though? What about ISIS recruitment tools? Under U.S. law, certain types of speech, obscenity, fighting words, to your question about why could Trump get in trouble for inciting a riot? Well, if that's what he did, the First Amendment doesn't apply. We call that fighting words. And true threats. These are not protected by the First Amendment. But are social media companies responsible for doing the government's work for them, for regulating that on their platforms? Pavel Durov, he is the founder of Telegram, which is a form of Twitter, Facebook, that's used in other areas of the world, not as popular here, although it's available. Some of you may use Telegram. He is notorious for making a platform that is largely unregulated. He said, I'm not going to censor speech on this platform. I'm not going to monitor it. And I'm not going to turn over my users to the government. Well, he just got arrested in France. France is blaming him for child pornography, ISIS recruitment, other illegal things that are happening on the platform. And they're pressuring him to identify the people responsible, or they say, we'll hold you responsible. Social media is playing a role in politics. Elon Musk, the founder of X, he is also a Trump supporter. He is donating millions of dollars. We might presume it's in a super PAC. We don't know exactly who's donating what, but we know that he is a supporter. So could X be used to support a particular presidential candidate? Is that a problem, even if it was? Meta, Facebook, is taking the opposite approach. So Zuckerberg says, we want to get out of the politics business. And then, of course, we have foreign actors like Russia that are using social media to attempt to influence our elections. Okay, aren't I supposed to talk about Supreme Court cases? Isn't that why we're here? Well, I just wanted to set this all up for you because all of these things are in the background of these 4 cases the Supreme Court decided. And I'm not going to talk about them in too much detail because the court really didn't do a whole lot. They largely punted, which is what lawyers say when the Supreme Court sends the case back or throws it out on standing or another threshold issue. So Net Choice v. Paxson and Net Choice v. Moody, Texas and Florida had come up with rules saying, well, Facebook, you seem biased against conservatives, particularly when people were saying things around COVID, about the federal government and COVID precautions. Facebook would limit those things. And they said, you can't censor your platforms. We want you to stop making these moderation decisions. Well, can the state tell a private actor like Facebook how to moderate their platform? Murphy versus Minnesota, around the same time, the federal government, the Biden administration, was allegedly influencing Facebook to promote their version of COVID remedies and to block what they saw as dangerous misinformation. Well, can the government do that? Can the government encourage a social media platform to promote a certain view, even if they think it's in the interest of health? And then finally, Link v. Fried, if, let's say Jehan has a social media account and she's tweeting about this event right here, and she says, we just had a great time at the Supreme Court review, and one of you writes a comment and you're like, nah, it sucked. Can she then eliminate your comment? Or is that government censorship? So, am I getting my warning here? Okay, well, I'll go through very quickly. Basically, they didn't do much. They sent a lot of these cases back to lower courts, and what we saw is that the justices, even though they went along or bipartisan lines, they largely didn't know how to deal with a lot of this stuff. Today, we're still dealing with these issues. We've got a TikTok ban that's being fought in court right now. We've got the metaverse. So once companies start not just regulating what you see and what you hear and what you read, but they start creating a virtual world that you operate in, can they make up the rules for that world, or does our government have the ability to influence that? Might conservatives literally live in a different world than liberals? Is that okay, or is that something the government should have concerns about? Not my problem. These are more the problems for your generation. So I introduce these for your study, for your thought, and finally, for your decision. Thank you. I think I used my question time, but that's up to Jehan.
One question?
Yes.
So, you said that the Supreme Court sent back a lot of the cases and didn't know how to deal with them.
Yeah.
Do you see in the future the Supreme Court adapting to, as social media becomes more and more as part of our lives? Do you see the Supreme Court actually focusing more on how to deal with those and adapting to it?
I think they're going to have to. And when you send a case back to the lower court, you're typically doing it for further proceedings. You're saying, all right, we're not going to decide this, but we don't think you analyzed it correctly. Here's a few tips on how we want you to look at it. Now look at it again. So that's what they did. These lower courts will now have to make a decision, and then it will probably be appealed again. So most of these cases will end up back before the Supreme Court in a couple years, and maybe by then they'll be ready to make a decision. Thank you.
Thank you to all you students who stayed here to the end. I really appreciate it. I also want to thank the students who helped out today. You know who you are. I really appreciate all of you. And then finally, thank you so much to all three of our presenters for coming here to our campus. There is a reception right outside, and if any of the speakers have a few extra moments to be out there for any additional questions.